Students, this will be the second video you've received from me, and I do want to mention we're a little bit different location than the office that I usually tape from, and we had windstorm last night that blew a couple trees on our cabin. So I'm out at our lake home by Ashland, and so the background's a little different, but if I lean over, I can see where my grandson left his fishing tackle box up here in the loft. So anyway, our guest today is Trent Steele, and Trent has quite a background in administration and also has a legal background, and he'll explain that to you a little bit. I do want to mention though that this is the second taping for us. We taped it a few years ago, and I have a little lighter hair and he has a little less hair than we had at that time, but I really have had a lot of students talk about how this video has helped them in this course, and how to study the law and how to look at a case brief. And one of the things that in this class that I do, I'm not great in memorization, but I want you to understand the concept, why that case is important. But I'm going to turn it over to Trent and talk a little bit about his background and his experience. I will mention that he is a UNK graduate and has always really been helpful for us in helping us do these videos and throughout the other courses. So Trent, I'm going to throw over to you, and you can tell a little bit about yourself, and then we can talk a little bit about why understanding the law is important for an administrator.
Thank you very much, Dr. Nelson. I would say that, first and foremost, yes, I am very, very proud to be a product of the UNK Department of Educational Administration. I completed my master's with UNK. I had Dr. Nelson as a professor, and my continued gratitude to you for the wonderful foundation you gave me, and I will always be grateful for that. Shortly after I obtained my master's, I started visiting Dr. Nelson's school law class. And then finally he decided, he said, well, let's video this thing. And then that way, we're not always needing to, logistically arrange for a time. And so I agreed to video it. And that video has been used. I think we made that video 15 years ago, and it was used over and over again. And finally, I think there's been enough feedback to Dr. Nelson indicating that the people involved in the video no longer look enough like they used to at the time of the video. So we need to update it a little bit, if for no other reason. So yeah, I've lost a little bit of hair, and I've gotten a little broader, and that's the way life goes. But it is always good to be with you, Dr. Nelson. To tell you a little bit about myself, I am currently serving as a Director of Human Resources and Student Services for our secondary buildings in the Papillion-La Vista School District. My first teaching job many years ago was at Kearney High School. I taught social studies there. After Kearney High, I took kind of a different course. I went to law school at the University of Nebraska-Lincoln, and I started doing graduate work in educational administration at that time, along with my law degree. While I was at the university, I served as law clerk for the State Attorney General's office in the area of criminal prosecution, and learned a great deal with that opportunity. I went back after completing law school. I practiced law in Kearney for a period of time, and then I really decided that I missed being in the schools, and it had always been my goal to be in school administration. And so I started out as a K-12 principal at Anselmo Myrna Public School, and then I was an assistant principal in Beatrice at Beatrice Middle School, and then I was in Kearney for several years as an assistant principal at Kearney High School. After that, while I was working on my doctorate in educational administration, I also worked for the Nebraska State Education Association in a role that they now call organizational specialist. However, it's at the time it was called a UNISERV director, but I served Central, Southwest, North Central Nebraska in that role. Very proudly worked for that organization, and then went to Papillion. So I've had kind of a lot of different roles. I've kind of bounced around the state over the years. I've served in Class D, Class B, Class A schools, and I've worked in the area of law and also in the area of advocacy and education. And what it all comes down to is I'm just very passionate about the law. When I was a senior in high school, I was a student at Omaha West Side. The year that a case came down that you'll probably be studying called West Side versus Mergens. And I just remember my high school being the focal point of a national story, and something that was precedent setting in the courts. And we had national news organizations, and as I learned more about not only that case but others, I found that the schools have really been the focal point for some very needed change in our society, and they've been the focal point for a lot of progress in our society. And so I've always had a passion for school law, and I always appreciate this opportunity to be with a class like this. What Dr. Nelson asked me to do originally, and I'm gonna put a disclaimer here. I am, number one, I am a member of the Nebraska Bar, and in good standing, and I still maintain my law license. However, I maintain it on what's called inactive status. So I am not currently actively practicing law in Nebraska. So nothing that you hear in this presentation, please don't construe that as legal advice or anything like that. I don't intend to walk that line anyway, because what my purpose here is to do is to talk more about the study of law as an academic exercise. And really, I have to tell you that in my years of study and doing graduate work, learning the law was one of the richest academic experiences I ever had. It was also one of the most rigorous. It was also very, very stressful. And it was, but it was something that was, I think, that made me a better thinker. It made me a better writer. And it's something that really meant a lot to me. So what I'm going to focus on is just how to approach that, how to approach studying the law. I'll never forget one of my first days in law school. I had a professor, it was for property class, and I had a professor, his name was Lawrence Berger. And we were in an auditorium. I think there were probably about 100 law students in that auditorium. And Dr. Berger, or Professor Berger, was he was very much a traditionalist, and he ran his classroom using Socratic method, which is a fascinating way to teach. But basically what he did was he guided us to his instructional outcomes totally through questioning. And it was all question and answer. And he was a master at being able to frame a question so that the student, if they had prepared, would give an answer, and then he could use that as a basis for learning. So he had a rule. He was very tough. He kind of shuffled into the classroom, I remember, and he never gave an assignment. Never gave a reading assignment. His only reading assignment was just stay ahead of me. That was it. So there was nothing in the way of in terms of syllabus or anything like that of where we needed to be. So the older law students had given us the tip that usually Professor Berger covers about 4 cases every day in class. So if you read 4 cases ahead, then you're probably going to be okay. So I read about 6 cases ahead just for good measure and was ready. And then that day, Professor Berger got to the 7th case. And for whatever reason, he started rummaging around his notes and he said, let's pick someone new. And so he said, Mr. Steele, is Mr. Steele here today? And my heart sank and my stomach went up to my throat. And I had actually given a cursory review of the case beforehand, but it was, needless to say, it was a very it was kind of a wake-up call for me in terms of my approach to law school. But I had an older law student really who was a great mentor to me, and his parents were in education, and he kind of I think took pity on me, and he said, the thing you need to understand about the law is learning the law is not hard. What's hard is learning how to learn the law. And I'll say that again. Learning the law isn't hard. Learning how to learn the law is the great challenge. Because in law schools, and anytime you study a law class, it's about trying to manage a lot of information that's thrown at you and trying to maintain it and learn it in a way that works for you. And I will kind of later on here go over a little bit of an outline of how you might approach looking at some of the cases that you're going to be studying. But needless to say, studying the law is a different type of study because it isn't about straight memorization. It isn't about memorization. It's about application. I had in my law school class, we started with about, I think there were, I don't know why I remember this number, but there were about 155 students in my law school class, and we lost about a third of them by the time graduation 3 years later. And the people who left, the people who struggled in law school were the ones that really struggled with that question of application. They would learn a legal rule, they would commit it to memory, but then when you would ask them, okay, here's a new scenario, how does this apply? That's where they would really struggle. And so that's the whole point of studying the laws is its application. What do we learn from it? How do we apply it to new things? How do you apply it to new things when you're working as a school administrator? So let's start with some basics. I want to just, and this is stuff that, and I've always said this, there's not a single thing that's taught in law school that a lot of times even elementary students know about. The concepts individually are not hard. It's the volume of information. But and I don't want to be in any way condescending or anything like that, but I think it's helpful to start with just some basics. We all know about the 3 branches of government. I think we all, we studied those in civics class. We talked about the executive branch and the legislative branch and the judicial branch. But obviously the law is focused on the study of the judicial branch. We know that the legislative branch is it's supposed to, as we know, make law. It's supposed to create law. The executive branch is supposed to enforce the laws and carry them out. And the judicial branch is supposed to interpret laws when there's a question. But the thing to remember about these 3 branches is all 3 branches in their own way do a bit of lawmaking. And that is a source of concern to some people, but it is the way it is. Obviously, the legislative branch, through passage of bills, the legislative branch can create law. But in addition to that, the executive branch, through the administrative structure, through all of the departments, whether they're on the national level, federal level, or the state level, departments create what's called administrative law through regulations, like Nebraska's Rule 10 is an example of that. And then also the courts create new law. They, through their precedents, create law, and we will talk about that as well. The bottom line that I would want you to remember, though, is that the decisions that appellate courts make, the decisions made in the judiciary, very often have the force of law that we as school administrators need to pay attention to. Okay, when you see a major case has been decided, then that's something that your ears should perk up, and you should be watching and listening to find out how it was decided. Let's talk a little bit about the structure of the courts, because this is important to know. We have, in our country, we have a number of different court systems. We have state courts, we have the federal court system, but in a general sense, those are divided into two ways: what they call trial courts and what they call appellate courts. And so the thing that I would want you to remember is trial courts are usually at a localized level, and they consider and decide upon what are the facts of the case. The trial courts determine what happened in the case. Did the defendant cause the car accident that resulted in injury to the plaintiff? That's a question of fact, okay? But appellate courts consider the rules of law, the questions of law. So in other words, an appellate court won't say, did the defendant cause the car accident? But an appellate court will consider whether or not a certain piece of evidence that helped shine the light on whether the defendant caused the car accident, whether that evidence was admissible or not. That's a question of law. It's not a question of fact. So in our, as I said, we have several court systems, many court systems in our country. There is a state court system in every state. Ours is no different. Our state courts are divided in this way. We have county courts, and then we have district courts. Both county and district courts primarily serve as a trial court function. In other words, that's where the jury trial is had. That's where they determine what in fact happened. The distinction, there are several distinctions between county and district courts, but one distinction in general, and this is in civil cases, is that district courts handle controversies, handle issues that deal with damage amounts that are greater than $51,000. So the district courts in civil matters deal with a lot of more high dollar amounts. The county courts deal with lower dollar amounts. So we have county and district courts. Then we have the Nebraska Court of Appeals. The Nebraska Court of Appeals is a relatively new appellate court, and it began in 1991 with a constitutional amendment. There are 6 members of the Nebraska Court of Appeals. Very often sometimes they will meet in Lincoln at the state capitol building in their chambers, and sometimes they'll go out and hold sessions in different courthouses around the state. Sometimes the Nebraska Court of Appeals will meet as a whole, what we call en banc, which means that's the whole court, or sometimes they'll do 3-judge panels when they go out and about. But the Nebraska Court of Appeals, most cases that are appealed from the district court, they go to the Nebraska Court of Appeals. There is a motion that can be made called a petition to bypass, which would allow the Nebraska Supreme Court to hear an appeal directly from from a district court. But in general, and that would be at the Nebraska Supreme Court's discretion, but in general, the Court of Appeals is the next level of appeal, and their ruling stands as the final decision unless the Nebraska Supreme Court grants a petition to hear it. So, and then of course we have the Nebraska Supreme Court, which has 7 members on it. So that's the state court system. The federal courts it's obviously a nationwide system. There are 94 district courts in the federal system. Federal courts, they hear cases involving constitutionality of a law. So in other words, if we're dealing with a free speech case or something like that, or search and seizure, that's a constitutional question. And guess what? Those happen in schools. And also cases involving laws, federal laws. Well, as we know, special education is a federal law. There are a lot of federal laws that apply to schools. So it's very frequent that school law cases get heard in the federal courts. As I said, there are 94 district courts. They are a case in federal court moves pretty quickly, actually. They have when you file a case in federal district court, the case is assigned a magistrate judge, and that's not even the judge that will preside over the case. The magistrate judge makes sure that procedurally everything is moving along as it should, and so they tend to move along. An appeal from a district court goes to the next level, would be the circuit court. There are 12 circuit courts in the United States, and a circuit court has 9 judges on it. We are in the 8th Circuit Court of Appeals here in Nebraska. And when a case is appealed from the district court to the circuit court, the circuit courts will hear the case in 3 judge panels. And then if a party is dissatisfied with the result of the appeal, they can appeal it to, and I used this term earlier, they can appeal to have it heard en banc, meaning by the court as a whole. That would be the next level of appeal. So they would hear, all 9 judges on the circuit court would then hear it. That would be the next level. And in most cases, that is it, at least in the federal court system. Parties who are not satisfied with those decisions can petition the U.S. Supreme Court to hear their case. They can ask the court to grant what's called a writ of certiorari, and this is a request for the Supreme Court to review the case. The U.S. Supreme Court usually is not under any obligation to hear those cases. It usually only does so if the case, if it might have some significance, if it might have some precedential value. The Supreme Court has its own very special set of rules. And usually I think that the way it works is that at least 4 of the 9 judges must vote for it to accept a case. So it's the U.S. Supreme Court is a fascinating institution unto itself. But they, as I said, and I think this is really interesting, they have heard some fascinating school law cases over the years that have had an impact, tremendous impact on our education system and also on our society as a whole. I'm gonna spend a little time there when it comes to, especially when it comes to appeals courts. Our court system, it relies on this concept of precedent, and we call it, it's a Latin term, it's called stare decisis. And what it means in Latin is to stand by things that have been decided. And it sounds kind of hoity-toity, but I would tell you that any kid can understand this concept of stare decisis and this idea of precedent. If I take my daughter's phone away for a certain period of time, she is going to automatically recount if that is consistent with how I handled a similar situation with her brother, and is going to remind me that in her brother's situation, we held it for this many days and we should do the same in hers. And so, I mean, kids understand this, and it's just this concept of consistency. And this is important because what happens with these precedents, and this is the key thing to know, is that the precedent has a force of law. When a case is decided by an appellate court, that precedent has the force of law. I will give you an example of this in Nebraska. Several years ago, the Nebraska Supreme Court heard a case called Daley versus Morrill County. And in the Daley case, there was what was under consideration. This was involved a teacher discipline case. We had a teacher, and by all accounts, the teacher had been a good teacher. There were no bad documentations there in any way, but the teacher allegedly thunked a kid on the head like this to get them to behave. And the district took action on this, and they went to a hearing. The teacher challenged the district on this and requested a hearing. And ultimately, the Board of, and it was a hearing before the Board of Education, and the Board of Education decided that the teacher should receive a 30-day suspension and also be ordered to undergo counseling, presumably, I guess, probably some kind of anger management counseling or something of that nature. In any event, the teacher, as you can in a teacher discipline matter, you can appeal a decision of the Board of Education to the district court. The district court actually ruled in favor of the teacher, and the Board of Education appealed. And so, in any event, one of the issues in the case was that the school district said that the teacher had utilized corporal punishment. And there was a statute on the Nebraska books, 79-295, and it was a really brief statute, and it just said that corporal punishment shall be prohibited in public schools. And the teacher said, well, how can you say I've committed corporal punishment? What does corporal punishment even mean? And it was not clear. And so the Nebraska Supreme Court used that opportunity to interpret that statute, and they basically held that that in when it comes to corporal punishment, the teachers are able to use physical force when it is intended to preserve safety or to protect the learning environment, but they cannot use it as a means of punishment. In other words, it cannot be done. Physical force can't be applied in a punitive way. Well, in deciding that case, the Nebraska Supreme Court, that precedent then took on a force of law. And that is now the law in Nebraska, and has been for some time, in that when it comes to corporal punishment, what does that mean? Well, it means that you cannot use physical force in a punitive way. But that's an example of how the courts, how their decisions have the rule of law. Incidentally, in that case, there's a really interesting dissent that one of the judges wrote that said, we shouldn't be doing this. If there's a question as far as what corporal punishment means, that's something that the group of people down the hallway and to the left, known as the unicameral, that's something they should write. That's not something we should write. And that gets into some philosophical questions from a judicial standpoint. But the bottom line is these cases have the force of law, and they are binding. The thing that I would tell you next is as you study the law, what you're going to be studying an awful lot is you're going to be studying cases. Cases like the one I just talked about, Daly versus Morrill County. Some of the cases are cases you've never heard of. Some of the cases are ones that you definitely have. Like I would assume you're going to read Tinker versus Des Moines and Bethel versus Frazier and some of those very famous cases. But when appellate courts make a decision, when they decide something, they write it down in what's called an opinion. So what you're going to be studying in this course is you're going to be studying court opinions. Mm-hmm. And basically what an opinion is, it is a written, it's a written record of their decision, and not only the court's decision, but why they decided it that way. Because what they put in that opinion, like I said, that takes on the force of law. And what happens is whether no matter what kind of court it is, if it's the U.S. Supreme Court, if it's a circuit court, if it's the Nebraska Supreme Court, if it's the Nebraska Court of Appeals, any appellate court, they collect their opinions and they keep them as records for all time. You may have seen lots of commercials over the years with lawyers who say, "Have you been hurt in an auto accident?" And right behind them, there's a shelf that has these beautiful leather-bound volumes, books that they have back there. And what those books are, those are collections of court opinions. And that's the way we used to do it in the law many years ago, is that when you would do legal research, you would go into a law library and you'd pull those books off the shelf and you'd find cases. And that's how you would do it. Nowadays, of course, it's all on the computer. But that's what those are. Those appellate court decisions are all stored, and they are maintained for all time. When you look at these cases, it's going to look kind of, there's some legalese that you might see that is going to, you might have some questions about, and really it's pretty easy to understand. Most appellate court opinions, when you look at them, number one, at the very top, they're going to have what court it is. Supreme Court of Nebraska, Eighth Circuit Court of Appeals, whatever the name of the court might be. And then it's going to have what's called a case caption. And the caption is going to, first of all, list the name of the party that is the appellant, okay? And also then they're going to list the appellee, okay? So in other words, the party that is appealing the case, they are known as the appellant. And the party that is responding to that appeal, they are known as the appellee. And so in those cases, that'll be all listed in the caption. They usually start out by listing out all of the judges who took part in the decision. They also list the attorneys who are involved. And then the court opinion will list the facts of the case, and go into great detail on that. They give the factual background. Then they have what's called the assignments of error. And what that basically means is that's when the attorney for the appellant decides, and the appellee, that's when they list out, here are the things, the appealing party lists out, here are the things that the trial court got wrong, and here's why we need to appeal it. So that's what's the assignments in error are. And then the opinion will list the analysis of the court. The thing of it is that when a court makes an opinion, not all of the judges on the court agree with the opinion. And sometimes it will be followed up by a dissenting opinion. And there can be multiple dissenting opinions, okay, when an appellate court case is heard. And these dissenting opinions do not have a force of law, but they can form the basis of reasoning for arguments later on down the line, should the case, or should a similar case, I should say, appear in front of that court again. And they might, and a different attorney and a different party might try their hand at applying that reasoning and invite the court to overturn its previous opinion. In these appellate cases, I think it's very important for you to understand and realize and recognize that which appellate courts have a binding effect on what we do as school administrators. So if you are a school administrator in Nebraska, the decisions made by the Nebraska Court of Appeals or the Nebraska Supreme Court are going to have a binding force of law over what we do, okay? Whatever their decision may be, like in the case of Daly versus Morrill County, where the court decides to define what corporal punishment is, okay, then we all have to, as school administrators, adhere to what that definition is and make sure that it's understood. Next, going up on the federal level, if it's the Eighth Circuit Court of Appeals, then that we have to follow. If it's a decision made by the Eighth Circuit Court of Appeals, Nebraska is in the Eighth Circuit, we have to, those decisions have a binding force of law. And then finally, anything in the US Supreme Court has the binding force of law as well. So if it, obviously any US Supreme Court case, that's going to be watched very closely. We had a case this summer that we were watching very closely. It involved some inappropriate comments by a cheerleader toward her school and her school district and her teammates. And there were some issues there dealing with the extent to which a school district can take punitive action against a student for off-campus conduct. Everybody was watching that case very closely because they knew that a US Supreme Court decision would have a binding effect on all of us right now. Now, there's something interesting about this that you also need to know. There are other state court systems out there. Illinois has a state Supreme Court, and Indiana has a state Supreme Court, and I mean the different states have these different court systems. Likewise, there are 11 other circuit courts besides the Eighth Circuit Court of Appeals, and so sometimes we hear about cases, but we have to keep in mind if there's a decision made by the Fourth Circuit Court of Appeals, it might be interesting, if it relates to schools, but it doesn't have a binding effect on us yet. Okay. Likewise, if the Iowa Supreme Court makes a decision about a school district and a school decision in Iowa, that doesn't have a binding effect on us. It could at some point. Let me explain. I had a situation a couple of years ago where I was an assistant principal, and we were searching a vehicle, and it was a student's vehicle, and the student gave us permission to search. We had reasonable suspicion to do so, but the student gave us permission anyway, and we conduct the search. And the parent, this was a relatively new family to Nebraska at the time, and the parent brought out a case, I believe it was from Ohio, brought a Ohio Supreme Court case and said, you can't do that. It says here, according to the Ohio Supreme Court, it says that you have to get the permission of the vehicle's actual owner before you conduct the search. And she said, I'm the owner of the vehicle. You didn't get my permission before you did the search. You only got my dog. And so, and that was interesting. And Ohio evidently has that precedent, but it's not binding on Nebraska. It's not binding on what we do in Nebraska. Now, I will only say this: be careful of those cases, because we had no precedent in Nebraska under Nebraska law for that. If the case went to the state Supreme Court, what could a lawyer do for a student in that situation? They could say something like, Your Honors, Nebraska does not have this court has not spoken as to this question before. However, your colleagues in the state of Ohio have. And this is the reasoning that was employed by your colleagues in the state of Ohio. And we would invite Nebraska, this court, to adopt the reasoning of the Supreme Court in Ohio. So it does have it can have some persuasive value, but it's not binding, if that makes sense. So we have to just monitor those courts. And again, when you're a school administrator, follow Nebraska Court of Appeals, Nebraska Supreme Court, 8th Circuit, U.S. Supreme Court. Those are the biggies that you really have to follow.
And I've heard you say before that often some of these major cases really started out as something small, and I know you've mentioned that to classes before, that sometimes something you think is going to be really small can explode on you.
That's exactly right. I mean, any of these cases, let's take, for instance, the case that was announced this summer by the U.S. Supreme Court. That was a case. It wasn't even involving school discipline. It was involving activity discipline, and it was involving a school activity, and it was some remarks that were made online, but it sure blew up into a big case, into a big thing. And I think that's I wouldn't want that to scare anybody or inhibit anyone from doing their job or doing the right thing. But I think with every case that we have, everything we deal with as school administrators, we have to be thinking both in the moment, but also in long term. What turns might this take? What impacts might our decisions have? And we just need to be very, very careful. A relatively small student discipline issue, it can erupt into a major case, like in the case of Bethel versus Frazier. The student in that case was making a speech to a school assembly. I don't recall. I off the top of my head, Dr. Nelson, help me here. I'm not even sure what the discipline consequence was for the student, but I don't think it was very great.
No, I think it was a point he wanted to make, and he didn't, as it turned out.
Right. But that's a situation that it literally became a federal case, and those things can can really turn on you.
Mhm.
I want to just tell you one last thing here, as far as you look at these cases. We've talked about the appellate decisions and how that works, but when you read them, I think there's a very helpful way to approach it, and it's called briefing a case. Um, this was the first thing that we were taught in law school, was how to brief a case. So when you brief a case, what you do is you basically take notes on the case as you read it. And some of these cases you need to read over and over. At least for me, sometimes it took multiple times for me to read it and understand it. But the first thing you want to do, here's what you want to have in your analysis. You want to take down all of the facts of the case, including the procedural history. You want to have a mastery of those facts. Those facts are important because as you compare the case with other cases that you're looking at, you need to have a background of the facts. Like, for instance, if you're comparing Tinker versus Des Moines versus Bethel versus Frazier, you need to know Tinker involved the wearing of a black armband. It was somewhat of a passive type of a protest. Bethel versus Frazier, that was a speech that was given in front of a school assembly, and the kid at issue had the microphone, and it was kind of a captive audience type of a situation. Those facts are important, and they help us distinguish between the cases. The second thing after the facts is you need to ask yourself, what is the question that's being presented by this case? What's the issue in this case? The courts sometimes courts take a very expansive view of what issues they want to decide in a case. Sometimes they go very narrow. So you need to ask yourself, what was the court really addressing? What were they deciding in this case? The third thing you want to do after facts and the question presented is you want to find out, what is the rule that the court is applying in this case? What is the rule of law that they're using as the basis for their decision? Is it a statute? Is it a prior case? Are they following their own precedent? Or are they creating a new precedent, which they can do? You always want to ask yourself, what is the rule that they are using? And then finally, you want to ask yourself, what is the holding of the case? What is their decision? And incidentally, I know that a lot of times in the media and people who report on court cases, they always say that the court ruled a certain way. The court ruled a certain way. The true legal insiders always say that the court actually held. Courts hold. They hold this. They hold that. They hold the holding is what we want to find out, is what did the court actually decide and what was their reasoning. So as you analyze these cases, again, facts, question presented, what are the issues, what is the rule that the court applied, what was their decision, what was the holding, and what was the reasoning for that decision. That is the best way. And I think if you analyze these cases according to that, I think you'll get more out of the cases and you'll have better notes, and it'll serve you better going forward.
Trent, we assign students about 4 case briefs in a class. We follow that format pretty much. The only thing that I have added to it is, what's the significance to the administrator, which allows them to kind of explain why this is important to them. And that's really what I grade is what the significance is to them. So one of the things questions that one of the students gave me, we talk about board policy, and some places it'll say board policy is the power of law if you ignore it. How do you feel about that?
Well, frequently board policy is, it quotes directly from the law. You know what I mean? So in other words, a lot of our board policies that we have are required by state statute. So in other words, I'll give you an example. Effective June 30th of 2021, the Nebraska legislature said that every school district has to have a professional boundaries policy. In other words, governing the relationships, the personal relationships between employees and students. And the Nebraska legislature was very prescriptive about what had to be in that policy. In other words, there had to be a definition of grooming. There had to be a definition of what is the accepted or the preferred form of communication between students and employees. The statute said that we have to provide examples of what grooming behaviors might be. So in that sense, when you're talking board policy, a lot of times we are told to do it by the Nebraska legislature or by the Nebraska Department of Education. These board policies are all voted on by the school board. So in terms of governing student behavior and staff behavior, employee behavior in our district, those have the force of law within our district, certainly.
Will you real quickly describe the difference between a school attorney and an attorney? An attorney that has specialty in school law.
Well, should I start with the hourly rate, or is that? No, here's the thing. We have obviously a lot of attorneys in the state of Nebraska. We have relatively very few attorneys who have an expertise in school law, because school law, it's so narrow and focused in terms of, and it's kind of unique in terms of some of the precedents and the things that it covers. It covers everything from student discipline to, building, projects and things like that. And so it's a very narrow area. It can deal with personnel matters, and there are some procedures that are very unique to schools that a lot of times general attorneys will not understand. And so in Nebraska, we have a relatively smaller number of people who focus on school law, and I would tell you they're very, very good. The Perry firm, the KSB firm, and I would say that in personnel matters, on the other side of it, the firm that NSEA uses, the McGuire Norby firm, Scott Norby, very, very good, and his team there. So, I mean, there's some people who have very narrow expertise. And I would say that as a new administrator, I think it's important for you to iron out with your superiors, what is the process? If we have a legal question, how do I get that answered? And some probably if you're a principal, your superintendent will say, well, I want to be the one to call the attorney. But I think it's important. I think it's hugely important, and it's an ounce of prevention versus a pound of cure. I think it's good to consult with your school attorneys if you have a question. Better to do that than to make a mistake.
Yeah. Well, I want to thank you for your time and your expertise in helping us out here. I just want students to know that other things that we're going to be talking about, obviously the transgender issues are going to be important, and social media is really I think a big thing with administrators right now and how to handle that. And so we'll spend a little time with some of those cases, which I hope will help them. But thank you very much for your help, and I'm going to stop recording here pretty quick. So
all right.